Welcome back to Organized, the business law breakdown. I'm your host, Professor Seth C. Orenberg, and today we're tackling one of the practical and fascinating aspects of the Uniform Commercial Code. We're talking about warranties. So let's start with a question. Have you ever bought something that didn't live up to your expectations or the promises on the box? Maybe it was that coffee maker that started dripping in the wrong way after a week, or a smartphone that wouldn't hold a charge for a year. It's frustrating, right? But what you might not realize is these situations are often covered by warranties, which are a legal safety net protecting buyers and holding sellers accountable. In our last episode, we focused on remedies under the Uniform Commercial Code, affectionately known as the UCC, and we remembered that the Uniform Commercial Code applies to sales of goods, and goods are things that are identifiable and movable at the time of sale. Today, we're shifting gears from remedies to talk about how warranties are created, how they protect buyers, and how sellers can sometimes limit those buyer protections. By the end of this episode, you'll understand the different types of warranties under the UCC: express warranties, the implied warranty of merchantability, and the implied warranty of fitness for a particular purpose. You'll understand how these warranties arise and what protections they provide. And you'll understand how sellers can limit or disclaim warranties and what restrictions they face when they try to do so. We'll explore these ideas with real-world cases, including a dispute over diamonds and a farmer's reliance on fungicide. Plus, we'll dive into some what-if scenarios to connect the dots and keep things interesting. So whether you're a buyer, a seller, a lawyer, or someone who's just curious about how the law impacts everyday transactions, this episode will give you tools to better understand the promises built into every sale of goods. Before we dive into today's cases, let's take a moment to unpack key concepts about warranties under the UCC. Warranties might sound like legal jargon, and we are going to cover some jargon today, but there are important, practical rules in contract law because they shape everything from everyday purchases to high-stakes commercial transactions. And there's more debate around them than you might think. So what exactly is a warranty? At its core, a warranty is a promise that the goods you're buying will live up to certain standards. Under the UCC, there's 3 categories of warranties that cover a wide range of situations in the purchase and sale of goods. First, there are express warranties. Express warranties are affirmative promises that a seller makes about the goods. These could be written, spoken, or even implied by a sample or model, but not implied as a matter of law, implied by facts. For example, if a seller says, this car gets 50 miles per gallon, that's an express warranty that it does so. It's a specific promise about the product. If the car doesn't meet the standard, the buyer might have a claim. Next, we have the implied warranty of merchantability. Unlike express warranties, implied warranties don't require the seller to say or do anything specific. They're automatically part of the sale. What do they promise? Well, implied warranties of merchantability mean that the goods are fit for their ordinary purpose. So if you buy a toaster, you can expect it will toast bread. And that's true whether or not the seller says so or not. If the seller sells something that purports to be a toaster, I think that's a reasonable expectation. If your toaster doesn't toast bread, the seller might have breached the toaster warranty. Finally, there's the implied warranty of fitness for a particular purpose. And this one is, as the name implies, more specialized. It applies where the buyer has a specific need, communicates that need to the seller, and relies on the seller's expertise to meet the need. So, let's say you walk into a hiking store, you tell the employee you need boots meant for icy terrain, and they recommend a pair that falls apart when exposed to cold weather. You might have a claim under that warranty. Now here's an important point. These warranties aren't mutually exclusive. A single transaction can involve multiple warranties at the same time. For example, a seller might make express claims about their product, while implied ones apply by default. Man, this makes it sound tough to be a seller. What if the seller doesn't want to be on the hook for all these promises, whether implied or express? That's where disclaimers come in. The UCC allows sellers to limit or even eliminate certain warranties, but it doesn't let them off the hook that easily. Disclaimers must be clear, conspicuous. Sometimes they have to even meet statutory requirements in language. And other law can prohibit the disclaimer of certain warranties in certain cases. If a disclaimer seems unfair or unconscionable, especially involving cases of safety or consumer protection, that disclaimer may not hold up in court. So that promise that children's toy won't kill your baby, not sure that's going to fly. Understanding these concepts is crucial because warranties are more than mere technicalities. They're about trust, and they reflect expectations buyers bring to transactions and obligations sellers have to meet. As we move into today's cases and scenarios, keep these principles in mind. They'll help us untangle the legal and practical questions that warranties bring to the table. Let's break it down with Doherty versus Ash. It's a case that's all about express warranties and how they're created, even in ways you might not expect. So a jeweler named Ash sold a diamond necklace to Doherty, a customer, who wanted something special for his wife. After the purchase, Ash provided Doherty with an appraisal letter. Now, an appraisal letter isn't just any letter. It's a certification that the diamond is of a certain nature. And this letter described the diamonds as being of, and I quote, the finest quality. Sounds impressive, right? Well, here's where things get tricky. First off, it's a little weird to call diamonds of the finest quality because we don't really evaluate them that way. The GIA, the Gemology Institute of America, actually grades diamonds in a pretty specific way known as the 4 C's: carat weight, cut, color, and clarity. So what does it mean to be of the finest quality? It's a little ambiguous and it's not directly related to any of those 4 C's. And according to Doherty, or maybe his wife, these diamonds actually weren't of the finest quality. I mean, as I mentioned, there are these industry standards, and let's set aside carat weight, but the cut could be excellent or not so good. The color could be letter grades that range from highest to lowest, and clarity can be from flawless to visible imperfections. In order for it to be of the finest quality, one might assume that it has to have the top ratings in every single of these characteristics. And this one didn't meet the cut. So Doherty sued, claiming that Ash's appraisal letter created an express warranty that the diamonds would meet this very high standard. Now, to the UCC, an express warranty is created when a seller makes a promise or affirmation about the goods. It becomes part of the basis of the bargain. So we do have a question about whether the appraisal letter qualified as an express warranty. Here's an additional problem with qualifying it. As I mentioned, the letter came after the purchase. When is the contract made? At the time of sale. So what about this letter? That's another reason why this is odd. It doesn't have the usual language and was provided after the contract. So what did the court say? The court said yes. The appraisal letter was more than a casual statement. It was an express warranty. It was directly tied to the sale and had the potential to influence the decision to buy or keep the necklace. See, what's important about this necklace was there was some right to return it. And so the letter was apparently provided to reinforce expectations that were set during conversations that were preliminary to the transaction. And it was during a time period where a return could have been made. So the court decided that it would apply these warranties in this case. And how about the description? It decided that the finest quality was more than mere marketing fluff, but by putting in a letter like this, it indicated it was part of the bargain and an express warranty. So what's the key takeaway here? Express warranties don't always have to be explicit promises made at the moment of sale. If a seller makes representations that shape a buyer's expectations, even after the deal is done, according to this precedent, those representations can relate back to and become part of the legal agreement. And here, Ash's choice of words, the finest quality, it sounds a little fluffy, but it wasn't just marketing fluff. The court decided it carried legal weight. It was a certification of the quality of something, and that's what we mean by a warranty. Promise that something is going to be true in the future, that these diamonds, and diamonds are forever, would be of the finest quality. Here's where it gets even more interesting. The court didn't even require Doherty to show that he actually relied on the appraisal letter. Instead, it focused on whether the seller's statement was part of the bargain. This highlights how the UCC prioritizes protecting reasonable buyer expectations over rigid reliance requirements. Doherty vs. Ash reminds us that words matter. What a seller says about their goods, whether in a label, a brochure, or in an appraisal letter, can create a binding promise. And it may be surprising that can happen even after the deal is done, but at least in this case, the court showed that it can. This is a lesson for both buyers and sellers. Be clear about what's promised and understand how those promises can shape the deal and ongoing obligations that continue into the future, which we know as warranties. Now that we've unpacked Doherty vs. Ash, let's explore some what-if scenarios to see how far this idea can go. First, let's stick with the jewelry theme. What if instead of giving an appraisal letter, the seller verbally told the buyer, "These diamonds are flawless"? Well, that should count as an express warranty as well. In fact, this is even more clear because the concept of a flawless diamond is actually part of the description of diamonds and should clearly be interpreted from a reasonable buyer who understands gems or stones that this is a representation of the nature of the thing itself. Does it matter whether or not the buyer actually relied on it? Well, according to Doherty, no. An express warranty would be created by the verbal promise or written descriptions, even without the buyer demonstrating that they purchased it as a result. Of course, in this case, the quality of a thing can relate to its price very reasonably, so it's not a hard case. So let's make it more complicated. What if the buyer didn't care about the diamond's appearance? What if instead the buyer was simply looking for some diamonds that were certified as conflict-free, and the seller says to the buyer, "These diamonds are ethically sourced"? And the buyer, who is looking for conflict-free diamonds, relies on the statement to make the purchase. Later, the buyer discovers these are so-called blood diamonds, diamonds that were brought forth from a mine that was acquired by force. So is this an express warranty or something else? So this is harder, right? This is harder because it's not that typical, although not completely rare, for a buyer to be uninterested in the appearance of a diamond. After all, diamonds are often bought for their appearance. And the statement ethically sourced is not directly in line with the promise of conflict-free, although certainly related. Did the buyer specify the purpose for the goods? Well, now we're moving into a new territory. You see, if the buyer actually said to the seller, "I want to buy conflict-free diamonds," and now the seller said the diamonds are ethically sourced, now we're moving into new territory where instead of dealing with some express warranties, we're dealing with fitness for a particular purpose, where there's some expression of the needs that has raised a particular issue to a critical factor. Let's switch gears entirely to something that has nothing to do with diamonds. Let's say you're a farmer looking to purchase a chemical that protects your crops. You explain to the salesman, "I need something that will stop specified disease here, fungal rot, without harming my plants." The salesman recommends a product which you buy and use, but instead of saving your crops, the chemical makes the fruit from them inedible. At this point, it's clear you didn't just rely on a general promise about the product's quality. You relied on the seller's knowledge and expertise to select the right product for your specific needs, and it didn't deliver. So here's the big question. Are we in the world of express warranties? Or where do we cross the line to the realm of implied ones? And if we have, what are the rules? To answer that, let's turn to another case, and we're going to break it down with Tyson v. Ciba Geigy Corporation. It's a case that highlights how the implied warranty of fitness for a particular purpose works in action, and why buyer reliance now makes all the difference. Again, remembering that for express warranties, we didn't have to prove buyer reliance, but this is a different case. So here's what happened. James Tyson was a North Carolina tobacco farmer dealing with a pesky problem, black shank disease. It's a fungal infection that can devastate tobacco crops. To address it, he turned to Ciba Geigy, the manufacturer of a fungicide called Ridomil. Tyson relied on the advice of Ciba Geigy's sales representative, who assured him that Ridomil would control black shank without harming his tobacco plants. based on the promise, Tyson bought and applied the product. But instead of saving his crop, the Rideau mill allegedly caused severe damage to Tyson's tobacco plants, leading to significant financial loss. So Tyson took the matter to court. He argued that Ciba-Geigy had breached the implied warranty of fitness for a particular purpose. Under the UCC, this warranty arises when a seller knows two things. First, the buyer has a particular purpose for the goods, and second, the buyer relies on the seller's expertise to provide a product that meets the purpose. So in this case, the court focused on three key questions. First, did Ciba-Geigy know Tyson's particular purpose? Absolutely. The sales rep was actually aware, not just recently aware, that Tyson was buying Rideau mill specifically to control black shank in tobacco crop without causing damage to the plants. So this wasn't any generic use for a fungicide. It was tailored to Tyson's specific farming needs. Second, did Tyson rely on Ciba-Geigy's expertise? And the answer here is also yes. Tyson wasn't an expert in fungicides. He depended on the sales rep's recommendation to choose the right product. And the company that sold it held itself out as a specialist in this type of product. This is reasonable. So that reliance created what is called the implied warranty of fitness for a particular purpose. And third, did Ciba-Geigy breach the warranty? The court said there was enough evidence to let a jury decide the case. If Rideau mill failed to control black shank and caused additional harm to the plants, then that would be a breach of implied warranty. So what's the big takeaway here? Tyson v. Ciba-Geigy reminds us that the implied warranty of fitness for a particular purpose is all about the relationship between the buyer and the seller. It's not just about what the product is or what the seller said. It's about whether the seller understood or should have understood the buyer's specific needs and offered a product that met those needs. The case also contrasts with express warranties, like the ones we saw in Doherty versus Ash. While express warranties depend on the seller's specific promises, implied warranties like this one hinge on the buyer's reliance on the seller's expertise. Together, these warranties show UCC's multiple forces that protect buyer expectations while holding sellers accountable for the promises they make or the expertise they claim to have. Let's leave the courtroom and step into the pop culture world of luxury jewelry, where warranties can be just as important as the jewels themselves. One of the most iconic names in the luxury jewelry space is Tiffany & Company. You've probably seen their famous blue box. It's a global symbol of quality, elegance, and trust. But what you might not know is how Tiffany backs that trust with legally binding warranties. Because when you buy a Tiffany diamond, you don't just get the jewelry, you also get a Tiffany diamond certificate, which authenticates the quality of the diamond, specifically including its cut, clarity, and carat weight. And here's the kicker. Tiffany offers a full lifetime warranty on many of its pieces. The warranty guarantees the jewelry is free from manufacturing defects so long as you own it. So if you buy a ring from Tiffany's and the diamond falls out, and you can show that it fell out not because of your abuse, but under reasonably normal conditions, you may get a replacement, which is unusual because you don't necessarily have that guarantee. Why does it matter? Tiffany's diamonds cost more. Tiffany's rings cost more than getting it from other places. And they may be worth it because these warranties are effectively legal promises. The Tiffany Diamond Certificate is an example of an express warranty under the UCC. It's an affirmation of fact that guarantees the quality of the goods being sold, even after the contract has been fully performed on both sides. That full lifetime warranty, that's a built-in assurance that if something goes wrong due to a manufacturing defect, Tiffany will make it right. Now again, buyers pay for this on the front end, along with maybe the prestige of that blue box. But there may be some value on the back end. Tiffany's approach isn't just about protecting buyers. In fact, Tiffany's job is to make money for Tiffany & Company. They do that through maintaining the brand's reputation. So for a company that prides itself on quality, these warranties are more than a legal obligation. They're a promise to uphold the trust of every customer who opens that little blue box. So next time you're admiring a diamond or any luxury item, think about what the seller is really promising. Is there a warranty attached? What does it say about the seller's commitment to quality? As we've seen in today's cases, these promises can carry a lot of legal weight. But here's the thing. Sellers don't always want to be on the hook for these promises. Maybe companies like Tiffany's build their reputation on going above and beyond what the law requires. But what if a seller wants to sell them the cheap? If you ever bought a used car, you might have seen it marked as is. Can a seller disclaim warranties? Can they avoid having to abide by the law of express and implied warranties? Under the UCC, a seller can, under certain conditions. They have to follow specific rules. Let's start with the warranty of merchantability. The warranty guarantees that goods are fit for an ordinary purpose, and a seller can disclaim it. But the UCC requires that disclaimer of the implied warranty of merchantability be clear and conspicuous, and it actually has to use the word merchantability, such as, the seller makes no warranties, express or implied, including the implied warranty of merchantability. How about the implied warranty of fitness for a particular purpose? Again, that arises when the buyer relies on the seller's expertise to provide goods suitable for a specific need. To disclaim this warranty, the seller must include language that again is clear and conspicuous, and broad disclaimers like goods are sold as is or with all faults can negate implied warranties if properly presented. And how about express warranties? Those are harder to disclaim because if a seller makes a specific promise or affirmation about goods, courts generally don't allow a disclaimer to erase the promise. In fact, it's kind of like a battle of words. If a seller promises that a car has 50,000 miles on it and then has fine print later in the contract saying no warranties are made regarding mileage, that's not going to work. For one thing, it creates an ambiguity. Ambiguity should be construed against the drafter, and the seller's probably the drafter here. But in addition, as a policy matter, the UCC prevents disclaimers from negating explicit and express representations. Now again, these disclaimers have to be clear and conspicuous, and the UCC defines that as language that is noticeable and understandable to a reasonable person. Sometimes you see this in all caps. It could be larger text, bold, or a distinct section labeled warranty disclaimer. It doesn't actually have to be all caps, but that seems to be the popular way to appear conspicuous, even though, frankly, all caps is harder to read. And why do disclaimers matter? Because they balance interests, protecting sellers from unexpected liability while ensuring buyers aren't misled. Courts take these factors seriously, and improper disclaimers leave sellers exposed to claims that they thought they may have avoided. As we wrap up today's discussion, let's step back and think about the bigger picture of UCC warranties. These legal concepts aren't just about resolving disputes. They play a critical role in making markets work more efficiently. First, we explore the nuts and bolts of warranties. Express warranties arise when sellers make specific promises or descriptions about goods, and those set clear expectations from buyers. They're hard to disclaim in writing because that would make the writing ambiguous. Implied warranties, like the warranty of merchantability and fitness for a particular purpose, automatically provide assurance that goods will perform as expected, especially when buyers rely on sellers' expertise. And these can be disclaimed so long as it's clear and conspicuous. We saw the ideas in action through Doherty vs. Ash, where a jeweler's description of diamonds as the finest quality created an express warranty, and in Tyson v. Seba Geigy Corp., where a farmer's reliance on a seller's recommendation on fungicide triggered an implied warranty of fitness for a particular purpose. But why do these rules matter in the context of the economy? Warranties serve more than just legal safeguard purposes. They're also tools for promoting trust, quality, and efficiency in the marketplace. Think about it this way. Warranties allocate risk. When a seller guarantees the quality of their product, they assume responsibility for defects. That incentivizes them to maintain higher production standards, improving overall market quality, and it puts risk on the party that can most likely reduce the risk. Warranties reduce information gaps. In many transactions, sellers know more about their products than buyers do. In offering warranties, sellers bridge information asymmetry, giving buyers confidence in their purchases and ensuring smoother transactions. And accordingly, warranties act as market signals. When a seller offers robust warranties, it tells buyers we stand by our products and maybe shows that they're worth more. This not only builds trust, but differentiates high-quality sellers from low-quality competitors, creating a transparent and efficient market for buyers of all different qualities of goods. And let's not forget about economic efficiency. By having a default rule which represents what most parties would tend to choose, we minimize costs of negotiation. And down the road, we minimize disputes and litigation. As you reflect on today's cases, remember this. Warranties aren't just legal concepts, they're economic tools in the marketplace. They ensure buyers and sellers interact with confidence. They balance risk and reward, and they benefit everyone involved. As we close this episode, I encourage you to think about the role warranties play in your life. Next time you make a purchase, whether it's a car, a smartphone, or even a cup of coffee, ask yourself, what's really being promised here? Is there an express warranty in the form of a label or a guarantee? Is there an implied assurance that the product will work as expected? Is there a disclaimer that says you can't trust them? For students preparing for exams, you might try crafting your own what-if scenarios, because changing the facts a little bit, like the type of the warranty, the way that it's disclaimed, or the buyer's reliance or that reasonableness of reliance, can affect the outcome out of the UCC. For professionals, you might review your contracts. Are the warranty provisions clear, enforceable, conspicuous? Are you offering warranties that reflect your confidence in your products? Or did you unintentionally create promises you didn't mean to make? If you enjoyed today's episode, don't forget to subscribe, leave a review, and share it with someone who'd appreciate a deep dive into the world of contracts. Your support helps continue these fascinating topics as we expand our podcast into new episodes. And as always, if you have questions or stories about warranties or anything else in contract law, send them my way. I'd love to hear from you and keep the conversation going. In our next episode, we'll explore our last topic for this season: third-party beneficiaries, which is when someone who isn't party to a contract can still enforce its terms. It's actually full of surprises, and I can't wait to break it down with you one last time. I'll see you then. For now, that's all for today's episode of Organized, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and I thank you for joining me as we explore the fascinating world of contract law. Remember, understanding the promises behind a contract isn't just about passing exams, it's about navigating the complexities of commerce with confidence. And so, until next time, keep your agreements strong and your arguments stronger.